This is Judge Torem calling our pre-hearing conference second one for March 20th, 23. It was supposed to start at 1:30 today. It's now 1:34. This is in the matter of the application of Scout Clean Energy, LLC, and better known as the Horse Heaven Wind Farm project in Benton County. I'm going to do a roll call now. For the applicant, do we have Crystal Chase?
We do, Judge Torem. This is Crystal Chase, and with me in the same conference room is Ms. Schimmelfenny and Mr. McMahon.
All right, Ms. Chase, I'm going to ask you to spell the last names of all of the parties that you just mentioned, and we'll take it that the first names the court reporter can pick up.
Great, happy to do that. This is Crystal Chase, last name C-H-A-S-E. With me here in the room is Tim McMahon, M-C, capital M-A-H-A-N. Also with me in the room is Emily Schimmelfenny, S-C-H-I-M-E-L-P-S-E-N-I-G.
All right, thank you. Counsel for the Environment, do we have Ms. Reineveld?
Ms. Reineveld is present. Sarah Reineveld. Reineveld is spelled R-E-Y-N-E-V like in Victor, E-L-D like in dog. Thank you.
Thank you. Good afternoon. And for Benton County, do we have Mr. Harper?
Good afternoon, Your Honor. This is Ken Harper for Benton County, H-A-R-P-E-R.
Anybody else with you today, Mr. Harper?
My colleague Z Foster is also with us today.
All right, great. And Ms. Shepard, if you need any of these other names spelled again later, just be in touch with me. Staff will make sure you have my phone number and email contact. All right, our intervening parties, the Confederated Tribes and Band of the Yakima Nation. Shona Volkers, are you with us today?
Yes, Your Honor. Good afternoon, Shona Volkers on behalf of Yakima Nation. My last name is V as in Victor, O-E-L-C-K-E-R-S. My colleague Ethan Jones is not present today, but my colleague Jessica Houston is also on the line.
Excellent. Welcome all. And finally, Tri-Cities Cares. That's an acronym, C-A-R-E-S. It stands for Community Action for Responsible Environmental Stewardship. Do we have Mr. Richard Arambaru?
Present, Your Honor. The last name is spelled A-R-A-M-B-U-R-U. All
right, thank you very much. So we've got all of our parties accounted for today, and I wanted to see who else is on the line for FSEC staff. I believe we have Jonathan Thompson, our Assistant Attorney General. Mr. Thompson, if you could just acknowledge.
Yes, I'm present.
And we also had Lisa Massengale, M-A-S-E-N-G-A-L-E, and Andrea Grantham indicate they could hear me on the voice check earlier. Is there any other FSEC staff present that wants to be acknowledged? All right, not hearing anybody come off mute right away. We will move on to the next agenda item.
One or both of them are parked outside.
Judge Torem, this is Andrea speaking. You might have been muted. If you could
Sorry,
try
Judge
out...
Torem. Can you unmute yourself, please?
Yeah, try *6 or #6 since you're calling in.
Okay, excellent. It sounds like I'm no longer muted.
There you go. Yep, you're good.
Thank you, staff, for helping me hear that I got muted. I heard some other lines, so maybe you just muted all the other lines. If there's other folks that are listening in today, that's great. This is a procedural pre-hearing conference to go over details about scheduling the upcoming adjudication and a number of other rules that we're working on. If you're listening in, please keep your microphone muted so we don't have to do that all mute again and result in actual people that have a speaking role getting cut back. There is no public comment opportunity today, but there will be at the adjudication. contact FSEC staff if you're worried about that or want to know what the procedures will be. And finally, just to be sure, there's no evidence being taken today. These are just planning discussions with the parties. All right, our pre-hearing conference order got out to parties quite later than I thought it would, but it's been a busy week since we last talked on March 10th. And the agenda hopefully went out with it. For those that are following along, I believe the agenda got posted on the FSEC website, but I'll walk everybody through it. So if you don't have it in front of you, it's obvious what we're doing. We have a total of 7 listed items, the first of which was the roll call I've already gone through. And the second one we're going to get to now is an update on the venue for the adjudication. After our call on March 10th, reached out and talked to the FSEC manager and relayed the party's feelings about wanting to have this either virtual, hybrid, or in person in the county, in Benton County. This, as I said in the agenda, has been raised with Sonia Bumpus, and she was going to meet with Chair Drew sometime after last week's Wednesday regular monthly meeting of the FSEC Council. I haven't heard anything back from Ms. Bumpus on that. We last talked by email, at least on Thursday, and I don't have any updates on decisions. There's some question as to whether or not having some portion of the adjudication in Benton County might be approved so that at least the parties and the judge and whatever staff we need might be present in the county. And perhaps the council members would not be imposed upon to travel to each and every session, but might be able to make it to some, if not all of them. For some council members, it may prove too much of a burden to do the travel, and I know that Chair Drew is considering those kinds of things. What I'd like to do is, as it says in the agenda, ask for those parties that would like to write a letter to Chair Drew and to me with the reasons in your own words, rather than the ones I might have relayed to the manager last week, stating why you believe it should be held however you want. Today being the 20th, I would hope that those could be, it's a Monday today, if by next Monday, March 27th, all the parties that are interested in filing their request for in-person, hybrid, virtual, you could file those. They're totally optional, but if we could get that in by next Monday, the 27th, that would help, I think, Chair Drew understand where everybody's coming from and be able to make a more informed discussion. Ms. Volkers, I did relay, and I think you heard a little bit of that at the council meeting, the importance of the special request you made on behalf of the Yakima tribe for your elders to testify. And you might want to have an additional portion of your letter explaining essentially the logistics that might be necessary and any support on how to record the voices that they might speak in. Again, you said they would speak in perhaps a native tongue as well as in English to express their positions. And what my only concern, as we talked about 10 days ago, is if there would be any gesturing or other things that couldn't be captured in a written transcript of words in English, whether we'd need an interpreter or some other way to capture that for the record. But I leave that for you to describe if there'd be any necessary additional support to capture the testimony and presentation of your elders. Does any party, I'll survey one at a time, have any concerns about filing a letter by next Monday, the 27th? And Ms. Volkers, when I get to you, any other special requests? Let me start with the applicant, Ms. Chase.
This is Ms. Chase, no concerns about that deadline.
All right, Ms. Reineveld for CFE.
This is Ms. Reineveld. I have no concerns with that deadline either. Thank you, Judge.
You're welcome, Mr. Harper.
Ken Harper for Benton County. No, Your Honor, that's fine.
All right, Ms. Volkers for the tribe.
Thank you, Your Honor. No concerns. Just to confirm, you would like this letter addressed to Chair Drew or to yourself?
To both of us, please. That way, she and I might have cause to talk about all of the inputs once they're all in.
Understood. Thank you.
And Mr. Arambaru?
For Tri-City Cares, no concerns with that time schedule.
All right. Well, I hope all of you will take advantage of that opportunity to communicate directly with me and the chair with regard to your preferences for venue. And it'll, again, just give you all a forum to get that out in your words. All right. Let's turn to the third item on the agenda for today, the actual scheduling of the adjudication itself. We are still working with the deadline of July 8th, 2023. I think a number of you heard what I had to say about that at the monthly meeting last week. Let's take a look on the agenda. What I've stated is that the approved second extension request from the applicant does require us to get a recommendation to the governor no later than July 8th of this year. We've had at least 25 months that have elapsed since the application came in, and the current statutory deadline has certainly been passed. That 12-month processing time for 80, 50, 100 is well past, and we're projecting a total of 29 months at this time to get a full vote and consideration on the application. Based on our discussions 10 days ago, you can see the proposed dates that would have started perhaps as early as Monday, May the 15th for the hearing are now based on pre-filed testimony coming in no earlier than April 3rd or maybe April 10th. The earliest hearing dates, Ms. Chase, that I can offer the applicant and the other parties look to be Monday, June 5th for that entire week, and the remainder of the week after Juneteenth on that holiday from June 20th to the 23rd. I'm wondering for the parties just how many days of hearing you'd each estimate this case might take. And I realize it's a little bit of a shot in the dark because you don't know, we haven't agreed on what issues will be adjudicated or what witnesses. But based on your prior experience, and I know many of you on the line have been in complex litigation like this, including before this council. So I want to ask you, I can't hold you to it, but just your today, an estimate of how many days of hearing time you each think it might take. Let me start with the applicant again and see, Ms. Chase, between you, Mr. McMahon, and Ms. Schimmelfennig, what you're thinking for the number of dates.
Thank you, Judge Torum. This is Ms. Chase. I think based on the information we have now, we would anticipate a couple of weeks, so 2 weeks total. Recognizing that that will depend in large part on how the issues get finalized. And then also for this scheduling discussion, I did want to share that applicant will be submitting a third extension request shortly, if it hasn't already been submitted, that will extend the time to complete the adjudication through the timeline that you've been discussing at the last pre-hearing conference, which is September of 2023. So I wanted to share that now as it may inform the party scheduling discussions.
Well, I appreciate that. If the application extension request is actually being filed today, it won't be acted upon until the council can receive it, but it notionally will release a lot of pressure on everybody on the line today. I do appreciate that very much, and I will thank the applicant for allowing the council to be able to do a thorough job, and all the other parties, frankly, to prepare testimony less under the gun and really get a thorough adjudication on the issues they'd like to present. So your estimate for the amount of time is going to be approximately 2 weeks. Let me turn next to the Council for the Environment and see, Ms. Reineveld, your thoughts on how many days of adjudication this might take.
I would be in an agreement with the applicant, although I do think that there are a lot of unknowns to this litigation, including just the number of witnesses that are going to be called. So it's difficult to determine without that. I would say that at most we will likely be calling 1 to 2 witnesses. And so I just don't know the number of witnesses from the other parties. But I think, probably 1.5 to 2 weeks would be a good estimate.
Okay. Mr. Harper for the county.
Ken Harper for Benton County. Yeah, I think Ms. Chase has a pretty good best estimate there. I don't think I can really add to that. 2 weeks sounds about right with all the disclaimers, but it does sound about appropriate.
All right, thank you, Mr. Harper. Ms. Volkers, how's the tribe feel about predicting how long this might take?
Thank you, Your Honor. I don't have any better ability to predict and would agree with the statements that have already been made by other counsel.
All right, Mr. Aramburu?
My understanding is that the hearing time that we're going to take is going to be principally cross-examination with some exceptions. So if that's the understanding, then I think 2 weeks would probably be fine. Although these dates that you have here probably are not the appropriate 2 weeks in our view. So we think 2 weeks is fine, closely coordinating cross-examination time and those kinds of things.
All right, thank you. When you say these 2 weeks I have here, you're referring to the weeks in June that I mentioned and that are listed on the agenda.
That's correct, Your Honor.
Okay, and as Ms. Chase indicated, if the council approves an extension to the end of September, which I thought what I understood, Ms. Chase, would be through September 30th.
This is Ms. Chase. Yes, that's correct.
All right, so Mr. Aramburu, that's that's going to give us the month of July, the month of August, and the month of September to process the application, and the hearing time would certainly not have to start as of June 5th if that extension is approved at the April council meeting. All right, well, thank you all for validating what I told the FSEC manager last week on Wednesday afternoon or Thursday, whenever it was Ms. Bumpus and I spoke. I estimated 2 weeks, and I think she was a little bit surprised actually that we would have 2 weeks worth of hearing time. I hope we can knock it down to less as we sort out the issues and the number of witnesses, and particularly knowing, as Mr. Aramburu pointed out, if the pre-filed written testimony comes in, then we'll be able to have mainly an adoption of that on the record and cross-examination. And Mr. Aramburu, as you've pointed out previously, we'll be working with exhibits and a number of other things. If we do our pre-hearing housekeeping correctly, everybody will have exhibits and know exactly where we're going with them for each witness. We'll be doing advanced discussion and preparation so that the hearing time itself is used efficiently and everybody won't have to pause to get exhibits and things like that. I'm not sure today that I can tell you what weeks are available. I've received in an email earlier today a listing of council unavailability out through September 30th. So notionally, we could talk about that if I'd actually read that email yet, but I'll confess I have not. I have that information, and I believe all parties have also filed their notices of unavailability. If there's any party who has not done so as of today, I won't have you self-identify on the line, but I think all 5 parties have submitted their requests for unavailability. And if not, if you can get it in by close of business today, that will give me time tomorrow to start doing some cross comparison of council availability and party availability and see what we have notionally beyond the July 8th current deadline. If I make an assumption that the council might act at their next meeting to approve it, then we can start to sketch out a schedule. So let me turn then to the pre-filed testimony piece of our agenda, item number 4. I think last time we talked about having 3 rounds of testimony, and I initially, based on discussions with staff, had proposed the applicant file first, and then a bunch of other testimony come in response, and then reply. I can't remember which of you wisely pointed out that in past practice, we allowed all testimony to come in the first round from all parties based on their issues, and then all parties have a chance to respond, and if necessary, rebuttal on a 3rd round. So I don't know, I want to survey again if parties have a preference on ordering and the type of 3 rounds of testimony and the intervals in between. I think we talked about potentially 28 days after the first filing for the next round, and then 21 days for the third round to come in. So I'm going to ask counsel for all of the parties, I'll go in the same order as usual, to comment on that if they have thoughts, and I'll take notes as we go. Let me start with the applicant, Ms. Chase.
The applicant has no preference between the 2 approaches and is fine with the allotted 28, 21 intervals, acknowledging that based on parties' different availability, those dates may end up needing to shift a few days as we plot out the schedule. I think it would be helpful to have, I think on some balance, I suppose it would make more sense slightly for all parties to file simultaneously, because then applicant, at least from our perspective, would have the ability to respond to the issues that were presented by the parties on the issues that they're wishing to present in this proceeding. And then I think the last comment would just be that as to timing, given that we still need to finalize the issues, the initial discussions of April 3rd and April 10th may be slightly ambitious, but we do want to make sure that we're getting an initial deadline as soon as possible. Thank you, Judge Tor. I'm happy to answer any questions.
Ms. Chase, given that the council may not act on the extension request until the 3rd week in April, which would put us, as I look at my calendar, at the April 19th meeting, would the applicant and all parties, I guess if we're going to do it simultaneously, be comfortable with the first round of testimony coming in, not knowing quite what the hearing dates are, but notionally knowing that they won't be in June? What are your thoughts on filing a first round of testimony ahead of next month's council meeting so we can get things rolling? And again, that's subject to identifying all the disputed issues, if not today, then shortly after today.
Yes, so for applicant, we have no objection and agree that we should start with our first round of filings even before the council has the opportunity to act on that request, understanding that everybody seems to acknowledge that the June dates are not practically realistic. But no, we have no objection to that as long as there's adequate time between when the issues are finalized for the parties to have a couple of weeks to get their first round of testimony together.
All right. Anything else from the applicant on the scheduling of pre-filed testimony or the topics we're covering before I shift to counsel for the environment? All right, hearing none, let me shift to Ms. Reineveld and ask for your input again on the rounds of testimony, the intervals, and potentially starting the filing. If we do it simultaneously, then that would apply to all CFE and all the other parties to be ready sometime between now and April, middle of the month when the council has their meeting.
Thank you, Judge. The Council for the Environment has a slight preference for the applicant filing first and then other parties responding and then reply or rebuttal. I don't have a preference on the intervals other than that they be sufficiently spaced out. And I would prefer to have the hearing scheduled and then to work from there in terms of the filing schedule. I don't think it necessarily makes sense to establish an arbitrary filing schedule in April and then have the hearing, potentially be in July. I just, from a kind of litigation perspective, I think we should schedule the hearing and then schedule kind of those filing deadlines accordingly.
And Ms. Reineveld, I think in a perfect world, I would agree 100%. There's a certain part of me that remembers somebody in our federal government talking about unknown unknowns, and we're dealing with those right now. But I don't want to waste the time between now and the next council meeting because every day is valuable. I think as of last week, we had 115 days to go to the July 8th extension. And if we do get an approved extension to September 30th, today may be the first day of spring, but the first day of fall may be the date that the council members are deliberating and we're trying to get an order out. So that September time, I don't want to be holding a hearing in September. I want to be evaluating what's going on with the filings and post-hearing briefs by then. So I just want the parties to think that the judge and the council need time to, after the adjudication, read your post-hearing briefs, make decisions, draft the recommendation, and work accordingly to get everything ready to announce and deliver to the governor. One other piece that's come to my attention in looking at the SEPA questions is that if the final EIS has to be part of the recommendation, that has to be finalized at least, I believe it's 7 days according to law before the recommendation goes to the governor. So that's another week of backing up time from any granted extension that has to be considered. But that said, Ms. Reineveld, I want to know when the hearing is too, so that we don't artificially put pressure to file that first round of testimony. So my thought is we may get a feel and a decision today on the intervals, and the soonest possible date, we may yet schedule a shorter pre-hearing conference to announce dates and work through those and then set the schedule depending on how far we get today. Ms. Reineveld, anything else?
That makes sense, Judge. I just want to make sure that there's ample time to be able to, actually submit testimony and call witnesses. And so I think that's my concern about just to expediting the process for filing prior to knowing the hearing date. So I appreciate that explanation.
100% understood. I don't want to rush anybody further. And if we do have ample time, and thanks to the applicant's intention or already filed extension request, we probably should. But again, I have to look at all those notices of unavailability and see where the jigsaw puzzle lines up. All right, that's my problem to deal with. You've told me what to think. So let's shift to the county now. Mr. Harper, thoughts on pre-filed testimony?
Ken Harper for Benton County, Your Honor. I have strong concerns about the concept of simultaneous filing with a target date of mid-April. I just, I'm very concerned about the definition of issues. I'm concerned about the status of SEPA. I share Ms. Reineveld's concern, but we don't need to go over that again regarding the sequence here from hearing date forward. But Your Honor, I don't know what really is going to be sort of the focal point of the hearing, of the applicant's position. I don't really know how the respondents and interveners may be able to work between themselves and streamline testimony with having to simultaneously hit that date as part of our own pre-filed testimony due date. So, Your Honor, from the county's perspective, we would strongly request at least a staggered series of filings and or, I know this isn't really what you want to know, but and or an initial pre-filed testimony due date somewhat later than mid-April.
And I was going to ask you if the nature of your concern is more the timing of a mid-April filing date without the full fleshing out of issues and other things, or if it's the you don't want to file simultaneously with the applicant with the county's issues, which is it both, or is it weighted more toward the timing?
Well, no, Your Honor, thanks for the chance to clarify. It's the combination of the two. I don't know that I've got a strong reservation about the idea of simultaneous filing, but that clearly puts more onus on the county, possibly the other responding party and the interveners to really, very carefully structure what that pre-filed testimony will be, which takes time.
Agreed. And I know the applicant knows what it's applying for, and the applicant knows what it thinks its disputed issues are going to be, maybe in a better position. But I do think each of the parties know why they're here in the case. They filed petitions for intervention, or as the county has been involved from the beginning as well, Mr. Harper, before your firm filed its appearance. So everybody knows why they're here. I'm a little bit honestly less concerned with the question of, well, what are we going to do? You're going to identify your witnesses at the same rate if you haven't already. So you will have a full period of time to respond. It looks like the 28-day interval to respond to the applicant's witnesses that they file. Again, if we need to extend it from 28 days, if we have a little more grace time longer to perhaps allow for some informal discovery or formal if necessary, that may be some way to accommodate the concern you're expressing. And I hope we can do that fairly so you don't feel that there's any trial by ambush or any other concern of any party surprising the others, any more than any other filing that comes into court might do. So, Mr. Harper, I'll give you a chance to respond to how I'm evaluating your concerns.
No, I think you've stated it, Your Honor. Thank you.
All right, let's move on then. And Ms. Volkers, we're working with pre-filed testimony questions and about intervals as well.
Thank you, Your Honor. We are not opposed to filing simultaneously, although I would note that we've been operating on the last discussion, last hearing conference in preparation to, in anticipating that we would not be asked to file that direct testimony in the same timeline that applicant is so comfortable with. But depending on when the date is set, we're not opposed to filing testimony simultaneously. I will say that I also have very strong concerns about the timing, and especially knowing that the applicant has submitted an application to extend a deadline that is still, frankly, quite ambitious. I think that, you know, walking back from the date of a hearing being set is what makes the most sense here and sets everyone up for the best possible process, even though we are under this timeline or time crunch. And I would just respectfully also push back a little bit on the language about wasting time. I think we're all working really hard to get caught up on a lot of materials the applicant has had years to put together, including an amended site certification application that was filed just months ago. So we, you know, do need that time to have a fair process here. So those are my comments on the timing. I think that we should wait till the hearing is set and walk back from the hearing and do so in a way that is fair, regardless of whether or not we're filing simultaneously or in a staggered situation. And then lastly, I would just note that those 28 days were agreed before the applicant went on the record and said that they were prepared to file in just a few weeks. So when we had that discussion about the 28-day timeline, there were no dates that were being proposed or agreed to by the applicant to inform that discussion. So again, I would submit that that should be as much time as possible, given the hearing date, once the hearing date is put on the calendar.
And Ms. Volkers, I just want to validate for you that when I said that there was going to be any wasting of time, that would be, you know, from my perspective of my time and the council's time elapsing towards that perhaps now September 30th deadline. So I didn't mean any implication or offense that the parties are wasting time. From a procedural standpoint, though, every day to me is precious, and I don't want to sit on my hands until the council meeting on April 19th. You know, that's a full month away from today, and we can make good use of that time, even if it doesn't include a filing deadline. It can involve a lot of other procedural progress to get to the first filing round. So again, that's what I meant there. I do see that my notes reflect that these other filing deadlines of being ready as soon as April 3rd or April 10th were not offered by anybody that I recall other than Ms. Chase as to when the applicant might be ready to file. So you're correct to bring that up and make a clarification. Thank you.
Thank you, Your Honor.
With those comments, Ms. Volker, did you have anything else to add?
Thank you, Your Honor. I would add one other thing, which is that I did listen to the discussion during the FSAC meeting last week, and I also heard that the staff team who's working really hard on the SEPA side and did not have a schedule to commit to on issuance of a FEIS. And so it seems like that would also be something that we'd want to avoid, setting arbitrarily limiting deadlines when the FEIS might also not be ready as early as the applicant would like it. And so that's my only other comment in terms of timelines, is that I don't know that we would need to have the adjudication be done any earlier than, I mean, given reasonable time to review. But if, you know, the FEIS is going to be months away as well, I would hate to have all of us working under really hard deadlines on the adjudication side that are months ahead of an FEIS.
And that's a fine point to make. I have no reason to believe that the staff would need an exorbitant amount of time to respond. I know there's a lot of comments on the draft EIS, but unless there's going to be a request from staff based on comments for a supplemental environmental review, I haven't been given any such indication yet, but that may be premature. I will bring that up with the staff that's handling the parallel SEPA evaluation that will be going alongside but separate from the adjudication, and make sure that that's a valid concern. If they think that they can't get things done within the timeframes that are currently set or might be approved for September 30th, I'll count on Ms. Moon and the rest of the SEPA staff to make sure the adjudication team is aware, so the right hand and the left hand of the FSEC Council and staff know what's going on here. Thanks, Ms. Folkers.
Thank you, Your Honor. Nothing else at this time.
Thank you. Mr. Arambaru.
Thank you, Your Honor. Richard Arambaru for Tri-Cities Cares. A couple of issues. Number one, I appreciate that the FSEC Council does meet once a month, but with no objections to the applicant's request, I don't know why we necessarily need to wait for that period of time. Isn't there some process available so that we can have a more rapid decision about that? So that would be a request that's coming from me, so we know where we are.
Let me address that right away, Mr. Arambaru, and just say it's possible that there would be a special meeting, but Mr. Thompson would have to work with the chair and indicate whether or not we can waive notice periods or give special notice periods. So there are still laws to comply with to get things done ahead of April 19th and clarify the dates for us. And I'm sure Mr. Thompson, hearing that concern, if he hadn't already had that notion, is making mad notes, and we'll be reaching out to the chair shortly after we hang up today. So that's in the cards as well, if it can be accelerated. And if there truly is no objection, if the applicant is just getting that filed today, we do need to give all the other parties an opportunity to respond and see. I don't want to assume that anybody on the line here today that's a party to this matter won't have a concern or objection. There may be one that we haven't thought about or hasn't been voiced yet. All right, so on to the other pieces of pre-filed testimony, Mr. Arambaru.
I agree with with some of the other parties that the agenda for pre-filed testimony is aggressive. I think we should be looking at dates for testimony testimony submission in perhaps mid to late June. One of the other concerns that we have had has to do with the preparation of the final environmental impact statement. We believe that the final impact statement should be available during the time the testimony is prepared, not after. So we would like to see if the schedule can be worked out to have that testimony or have that document ready at the time we go into our filing of testimony. So that would be another request. Regarding the timing, and I appreciate Judge Torm us being active during the interim time, the additional time we may have. I do think there are some motions that perhaps will be filed. I also think there may be some discovery that some of the parties would like. I think some of that can take place in the next month or so. That might be having some productive time available to us at that point. Regarding the testimony, I think I am an advocate of all of the parties filing at the same time and responses and replies. Um, there may be some issues that will come up, that a party will be filing on a subject matter that the applicant is not filing on at all. So from that standpoint, getting the direct testimony in at one time, having responses and replies, I think is the preferable way to proceed. Um, so those are my thoughts. The 21 day agenda or schedule for submission of testimony is probably fine. So those are my thoughts, and thank you.
Thank you, Mr. Andrew. And I know you've been through this before, so it's not that I'm giving any additional weight, but I know that you're commenting from a position of been there, done that, and I appreciate the insights there. I think I do agree with all the parties' concerns about being ready to file next month. The applicant has said that and may have a better idea of a list of witnesses, but I do hope everybody on the line is getting ready and identifying witnesses now. And as Mr. Aramburu stated, starting to do the drafting of any motions you think might be necessary on a sooner rather than later basis. And frankly, any informal discovery that can be done until we establish the actual rules that will apply beyond those that are in the law in the Administrative Procedures Act of RCW 3405 and those that are already adopted for FSEC practice within, I think it's WAC 463. I don't have the exact citation off the top of my head. It's been a few years. But look at those rules. That's what applies now. If you're going to ask for formal discovery until we adopt specific procedures for this adjudication, that WAC will govern, and hopefully all parties will adhere to those deadlines that are set in the WAC until we can figure out any special accommodations for this horse heaven adjudication. I wish I could tell you we could resolve everything about the pre-filed testimony today under item number 4, but I don't think we should or will, given the breathing room that we're being offered by the applicant's extension request that's announced to all of us today. I want to skip over the disputed issues list until we have our first break, because I don't think it does us any favors to start on that and then have to stop for a 10-minute comfort and court reporter rest break. I think if we go for another 15 or 20 minutes and talk a little bit more about discovery and maybe even the schedule for a next pre-hearing conference, that would be productive use of our time in the next 15 to 20 minutes. So let's turn to item number 6, the discovery. As I've already covered, there's informal discovery available under the Administrative Procedures Act. And I've listed 3 different adjudications from past experience. The Kittitas Valley Wind Power Project, which I presided over, the Whistling Ridge Project, that I believe that was Bob Wallace was the ALJ on that one. And then Cassandra Noble, I believe, presided over the Tesoro Vancouver Energy Project. Each of us probably issued different pre-hearing conference orders with slightly different discovery practices. I wish I could tell you I had time to read all 3 of those orders before today's proceeding, but I have not. I just know notionally how it went the last time I've been in complex adjudication before this council, as well as other proceedings I've been involved in. I wanted to hear from all 5 parties on what your thoughts are for any special needs for discovery that aren't addressed in one of those 3 orders, or if there's something in one of those 3 orders and you've had a chance to look at it that I haven't, you want to call my attention to, or just out of the WAC 463 provisions, if there's any need to tailor those for this adjudication. So Ms. Chase, I'm going to come back to you to start us off.
Sure, thank you, Judge Forum. This is Ms. Chase. I think applicant's view is that informal or that discovery is likely not particularly necessary here, but we understand that the current WAC and other provisions apply to authorize informal discovery and will cooperate as contemplated by those items. I think our view is that the procedure in the Kittitas Valley and I'm looking at the order on discovery procedures, pre-hearing order number 8 that you provided the parties or referred the parties to in connection with your your agenda last week. I think that makes sense to encourage the parties to cooperate informally if we're going to have informal discovery, and that you serve as the presiding officer if there are formal discovery issues that need to be resolved. And I think the other note that we would make is that in our view, the use of the pre-filed written testimony largely supplants some of the other items that you might need discovery for. So that's just a comment about how the parties will be working together in advance of the adjudication to narrow the issues and the scope of the items to be discussed with the pre-filed written testimony.
So, Ms. Chase, let me ask, I think all the parties may have a concern with wanting to do maybe some formal discovery, such as a discovery deposition of some witnesses. I know it's an incredible expense and trying to get people together to do those kind of things, particularly when we have pre-filed testimony that allows for the preparation of any cross-exam. But I believe there have been some limited discovery depositions authorized in the past, or at least agreed to by parties in these types of matters. If not, I don't remember them necessarily in the Kittitas Valley case. Has the applicant had any experience where their witnesses have been subjected to a pre-adjudication discovery deposition on or before their pre-filed testimony came in?
Your Honor, Tim McMahon here for the record, MCMAHAN. And having been involved in Wild Horse, Kittitas Valley, Whistling Ridge, in none of those cases have have the parties been allowed or have even requested, really. There was some request for discovery in the Kittitas Valley case or with depositions, but that did not end up being either necessary or allowed. So, you know, if you're asking about experience in prior FSIC proceedings, I don't recall that ever occurring, and it was considered to be a successful process to engage in informal discovery, and as Ms. Chase indicates, the pre-filed testimony largely, you know, I believe supplants the need for much of that. The only use of just depositions that I can recall was after the Kittitas Valley case was actually completed, and there were depositions taken prior to submittal of the record to the Washington State Supreme Court. And those depositions had a lot to do with accusations of ex parte contact and inappropriate behaviors, which were pretty soundly rejected by the Washington State Supreme Court. So, but again, I have not participated in actual cases where depositions were taken in lieu of informal discovery.
Mr. McMahon, did you participate in the Whistling Ridge matter?
I did.
Okay. I had a notion from staff or other things that I had heard about that case that maybe there had been some formal discovery and depositions taken, but maybe that's, you know, it's many years ago, so maybe memories are a little foggy.
Well, I don't recall it happening in Whistling Ridge.
Oh, I was referring to my recollection, and I wasn't directly involved, so
Right.
Who knows?
Yeah.
I certainly don't want to encourage parties. Go ahead.
Sorry, Judge. No, you. Sorry, Judge.
Well, I don't know for sure what happened there. There are other parties, and Mr. Aramber will come to you shortly.
Okay.
But I don't mean to encourage that parties should be seeking this kind of discovery, simply because it will eat up more time and cause more expense. And I do believe this practice of having everybody put their cards on the table up front avoids the need through pre-filed testimony for most, if not all, depositions of parties until you at least read what they're going to be saying. If you think there's more that you need to get, then we can talk about a motion for additional inquiry or to essentially voir dire a witness in a efficient manner that allows for the information for all parties to prepare for the adjudication. Mr. Aramburu, you were going to maybe enlighten us on your experience.
Yes, Mr. McMahon and I were involved in the Whistling Ridge case. There were some discovery issues there, but there were not depositions that were taken in that case. So I'll wait until I'm called on for other issues.
I'll tell you what, I'll call on you now since you're already thinking about it. Go ahead, Mr. Aramburu.
Okay, well, I don't want to cut in line here. For the issue of discovery, again, I think opportunity for deposition should be given, but I think they're of limited use here. More often, we have witnesses that are preparing and need information from the applicant or perhaps from another party, and there would be requests for documents, data requests, those kinds of things. That's what's more likely here as our witnesses prepare. So on the subject of discovery, I think we should have an opportunity for that kind of discovery, formal or informal. And perhaps we start with informal discovery. Will you make documents available, et cetera, et cetera. Then if we run into problems, we can go into more detailed procedures connected with discovery, including motions. So that's my thought on that.
All right, and I appreciate, Mr. Aramburu, the insights there, because I know in my day job as a Board of Industrial Insurance Appeals, Industrial Appeals judge, boy, if that's not a mouthful, I typically rely on perpetuation depositions for the expert testimony, and that is the testimony that comes in. So sometimes counsel perform discovery depositions before they're ready to cross-examine a witness they haven't seen before. But in this context, I don't think that same practice adds the value that it does in the labor and industries practice. So I would, at risk of wondering what the other parties are going to say, concur with what you've indicated so far, and think that the parties can get most of it done, especially on the more relaxed schedule we're anticipating informally. Let me turn to Ms. Reineveld and see if, in your experience, Ms. Reineveld, you are anticipating any formal discovery or any special needs.
Well, counsel for the environment agrees with the informal discovery procedures under the APA and proceeding with more formal discovery only if necessary. I also practiced, well, I was not a judge, but practiced before the Board of Industrial Insurance Appeals for about 9 years, representing L&I. So I did take many discovery depositions in that context, but I don't anticipate taking pre-adjudication discovery depositions in this context, just because of their pre-filed testimony requirements and the nature of pre-filed testimony. And the Council for the Environment doesn't anticipate any special discovery needs or preferences for this adjudication at this time.
All right, thank you, Ms. Reineveld. Mr. Harper for the county.
Ken Harper for Benton County. I think it seems like kind of a consensus is emerging, and I'm not going to dissent. We don't see a great likelihood of any special needs for discovery, any special preferences for discovery. I can't foreclose the possibility of some pre-adjudication deposition, but it doesn't seem like that's going to be the direction that the county goes. So, Your Honor, I think we're pretty comfortable with relying on good faith and APA-based discovery concepts. I'll just leave it at that unless you have any questions, Judge.
I don't. Let me hear from Ms. Volkers, and then I'll give you my thoughts on how we might handle any disputes in discovery, which I'll say up front, judges hate. Ms. Volkers.
Thank you, Your Honor. Shona Volkers. We would certainly like to avoid disputes on discovery. I would like to share a few thoughts and just acknowledge that a few of the terms that are being used are not ones that I'm as familiar with, so I might be imprecise in my language here in terms of formal or informal, but we agree with the statement that was made earlier that there's likely not a need to depose witnesses before they filed their written testimony, but we would like to reserve the right to file pre-adjudication depositions of witnesses that have submitted testimony, and we'd like to just, we'd like to see that testimony before we make that decision. But there might be an instance where we would be asking to depose a witness after they have filed their direct testimony. The other types of discovery that we are interested in are data requests, as Mr. Ambrew mentioned, more so than depositions, but we do think that we might need to depose one or two third-party witnesses, given the lack of a final EIS to have as part of the record. So likely would be technical staff on impacts of the project, that technical staff that carry knowledge that's important to this case, such as WDFW.
All right, so if I understand you correctly, the Yakima tribe would concur that informal discovery will likely work for most things, but once you see the first round of pre-filed testimony, you might want to file a data request before you file your responsive testimony to flesh something out. Is that an understanding first?
Thank you, Your Honor. I need to, I think, clarify my statements further. So the two types of discovery we anticipate would be data requests or some limited number of depositions. And as for depositions of witnesses of other parties, we would not request those until their direct, pre-written, direct written testimony has been submitted. In the meantime, though, we would potentially be requesting data and depositions of third parties, specifically technical staff with expertise on the impacts of the project.
Right. And I wanted to ask you about that second point separately, because
Okay.
when you say third parties, that may imply to me at least that we're not talking about a witness being sponsored or called by any of the other four parties that might have interests different from or adverse to the tribe. You mentioned the Washington Department of Fish and Wildlife, WDFW, as a potential party that you might want to seek a deposition from. And I would have to, I think, tell you, I may not have the jurisdiction to force them to testify in this matter, or be in a position to exclude testimony as a penalty for failing to respond to a request or a deposition discovery request. So I'm also trying to think from the perspective of who's really at the table here to present evidence, and what do you really need for the adjudication issues, and then what are other issues that the tribe may think need to be covered through either its independent consultation rights or through the SEPA process, which are separate and apart from what we're doing here in the adjudication. So I don't say that to prejudge, or it's not a no by any means, but it's a tell me more if and when that comes up, so that I can decide, is it something within the ambit of an administrative law judge for FSEC with an adjudication, or is that a decision that I'd have to defer and essentially say, no, I don't have the power to grant what you're requesting, and figure out what other alternate relief would allow the tribe to feel that they have had their day in court, not only in the adjudication, but before the council makes its ultimate recommendation, which includes some other moving parts that are not part of the adjudication. Fair enough?
Yes, thank you, Your Honor.
All right, so when we get to that portion of any more formal discovery, and again, when I use that term, Ms. Volkers, I'm thinking in my mind about things that would happen under the civil rules, such as formal interrogatories, requests for production, requests for admission, or the actual discovery depositions we've been talking about this morning or this afternoon. I forgot, it's 2:30. All right, so counsel, it sounds like a discovery process can be adapted from what I've done previously in the Kittitas Valley process. I remember there were motion practice in that case that I had to discover some or make some decisions. There were motions to strike testimony, There were motions to disqualify council members. There were a variety of things that happened. It wasn't quite everything under the sun, but it was an expansive and thorough, weighing of issues before we even got to the adjudication. So we'll talk a little bit more about the timelines at another pre-hearing conference, I think, once, and maybe, as Mr. Aramburu said, maybe we'll have a decision or at least a pending council meeting before April 19th to specially decide once we all see the extension request filed by the applicant today. But before we take our break, I want to ask everybody to look at their calendar and see if next week a shorter period of time on Monday afternoon might be available to meet again and wrap up these issues. And maybe by then I will have had a moment to come back with new timelines when the council might be available and have had a chance to look at your notices of unavailability and frankly just see how many of those requests can be accommodated and fit into the notional new schedule of getting a recommendation out by September 30th. My schedule next Monday doesn't really allow any time before the noon hour, and I have a 1:30 hearing that would have had me in Moses Lake, but the parties have agreed to do by Zoom. I doubt very much it's going to take more than 60 minutes to take one witness's testimony. So I think I could be available at 2:30 or 2:45 to have a much shorter pre-hearing conference and nail down dates. I hope that's not too optimistic, but if we nail the schedule down next Monday afternoon for the hearing with the contingency of knowing that the council was going to meet to approve this extension request, if we go on that assumption, who is available Monday afternoon, the 27th of March at 2:45? Would the applicant be available?
This is Ms. Chase. Yes, applicant would be available.
And let me put a bumper on the end time of that of 4:30, so that when you're saying yes, you'd be available, you know that I'm hoping we'd be done by 4. But if I go to 4:30, is that still a yes, Ms. Chase?
It is still a yes for applicant. Thank you.
Ms. Reineveld, would your schedule accommodate that?
Yes, my schedule would accommodate that. Thank you, Judge.
All right. Mr. Aramburu?
That would be 2:30 to 4. That would work on my schedule. Thank you.
Specifically, I'm looking 2:45 to 4:30.
2:45 to 4:30. I'll be available.
All right. Thank you, sir. Ms. Volkers?
Yes, Your Honor, that time works.
All right. And Mr. Harper?
Uh,
Now I've asked you last.
Yeah, well, and unfortunately, I've got a problem, Your Honor. That's a date that we secured many months ago for a significant mediation involving a number of attorneys. If we could revisit this perhaps after the break, I may be able to make some accommodations so that that we could handle that on the 27th.
All right, but what I'll offer you, since there's a potential problem, if all the parties would take a look at either the morning hours of the next day, the 28th, the hearing that I have in the Tri-Cities is scheduled to go from 10 a.m. until 3 p.m. So I have no objections to my old military hours as early as 7:30, but I think the court reporter contract is probably no earlier than 8. And we could do things from 8 to 10 or somewhere in that range, or possibly I would delay my return travel and we could do this between 3 and 5 on the 28th. My schedule after that gets a little more difficult, but I think I have time also on the 30th between 10 a.m. and 1 p.m. that I could shoehorn 2 hours of time in. But Wednesday is out, and I've got another couple of things cooking on the 31st. Maybe we could do it on the morning of the 31st as well. So if other parties could check their calendars for, again, the morning block of time, a couple of hours, and the afternoon on March 28th, Thursday midday from 10 to 1, on the 30th and maybe 8 to 10:30-ish on the 31st. I'll ask staff for our normal check-in on this to maybe move it to 10:30 to accommodate a pre-hearing conference if that's what we need to do. Council, it's now 2:40. I want to take a break until about 2:50 and give the court reporter a rest. We'll come back at 2:50 and pick up with our discussion of the disputed issues. I know some emails came in earlier today from several parties, I think Ms. Volkers, and I think Council for the Environment submitted their disputed issues this morning that I saw come in. So if you haven't received those, maybe reach out to other council by email or pick up the phone while we're on break. But I think it went out to everybody. All right. Will the court reporter show us off the record? All right, we're back on the record, and I'm going to do a quick roll call. Is Ms. Chase here for the applicant?
Yes, Judge, this is Ms. Chase. Thank you.
Thank you. Mr. Harper for the county?
Ken Harper for Benton County, I'm present.
And Ms. Reineveld?
I am present. Thank you, Your Honor.
Ms. Volkers for the tribe?
Shona Volkers, present on behalf of Yakama Nation.
All right, and Mr. Aramburu for TCC?
Present on behalf of Tri-City Cares.
All right, thank you. Mr. Harper, what did you find out about that schedule on Monday, the 27th, if that will work, or we need to look at an alternate date that week?
We can make it work, Your Honor.
Okay, so Monday, I appreciate the accommodation. That sounded like it might have been a big lift, but I'm glad you got it done. Let's count on then having a notice issued, and I'll work with staff, but tell you now on the record at 2:45 p.m. we'll get together next Monday, and we'll hope to be done by 4, but we'll schedule it to end no later than 4:30 on March 27th. And by then, I hope to have feedback from the chair on potential venue concerns, and again, have sorted out all of the unavailability orders as well. Let's turn to the disputed issues list. And Ms. Chase, did the applicant submit anything since the last pre-hearing conference?
No, Judge Torum, applicant has not submitted a disputed issues list or anything on this point since the last pre-hearing conference. I think applicant's view is that we've submitted the application or prepared to defend the application. And so the specific issues in terms of concerns about the application are for the other parties to identify. And just on that point that you just wrapped up, I wonder if we have a pre-hearing conference on the 27th, if it makes sense for folks to submit their venue items on a shorter timeline so that you can receive and consider those before the pre-hearing conference.
Thank you. That is a good point. So let's circle back to that first. How soon do you think the applicant would be ready to submit their letter?
We can submit it by Wednesday of this week or any other time this week that works for the other parties.
Okay, and if we are going to have feedback on that matter next Monday, and I would hope to, so we can decide maybe all of the scheduling issues, that might be overly optimistic. If we give folks, if it's going to be close of business today when we're done, or close to, until say Thursday morning, that would give 2 full days, tomorrow and Wednesday. Does any party I'll survey have an objection to me having you turn in your venue discussion that we talked about earlier, that letter by the morning of, say, 9:30 in the morning on Thursday, the 23rd of this month? Sounds like the applicant's okay with that. Would the county be okay with that, Mr. Harper?
Yes, Ken Harper for the county.
And Ms. Volkers for the tribe, would that be sufficient time to get your venue request, the concerns stated in the letter to me and to the chair?
Thank you, Your Honor. We can do that by Thursday morning.
Okay, Ms. Reineveld, does that work for you?
That will work for me. Thank you, Judge.
All right, and Mr. Aramburu, would that work for you as well?
Fine with us.
Okay, so we're accelerating that deadline to March 23rd, that's Thursday at 9:30 a.m. Thank you all for that. On to the other point Ms. Chase raised, I do appreciate the approach of, hey, we filed the application, so we already know what issues we think are necessary for the council to consider. I think that is just fine. I just wanted to make sure I hadn't missed any correspondence from the applicant in that regard. So thank you for clarifying that's the approach the applicant's taking. Let me turn to the county then and see, Mr. Harper, you had filed the disputed issues list last week, and some of that in conjunction with other parties. Was there any new filing since then that the county submitted?
There has not been a new filing to date, Your Honor. Ken Harper from
Okay.
the county.
All right, thank you. Then Ms. Reineveld, let me come to you because your email came in mid-morning today, if I'm correct in the timing. So it might be helpful.
It
Go
came
ahead.
in just right prior to this meeting or this pre-hearing conference, Judge.
And I'm pulling that up. Yeah, I see it 12:28 p.m. So you're operating on the same just-in-time production as I am on some of these things. I appreciate that very much. And hopefully with time, I will get caught up where I'm several days in advance and thinking ahead of all of you. All right, I'm looking at Council for the Environment's preliminary list of disputed issues. And as I would expect, they're mainly focused on environmental impact issues. All right, I'm going to ask the applicant to respond if they've had a chance to, first, Ms. Chase, to review these 5 enumerated issues, and if there's any objection or concern with how Council for the Environment has phrased this list of disputed issues with the limited additional guidance I was able to provide last week.
This is Ms. Chase for the applicant, and we have had an opportunity to review these issues, including because Council for the Environment shared these with us in, I think, essentially the same form last week, which we appreciated. And so we don't have any objections or concerns with these issues.
All right. Did any of the other parties have any concerns they wanted to speak to on the 5 issues that Council for the Environment listed? I'll ask the county first.
No, Ken Harper for the county. Thank you.
All right, Ms. Volkers, from the tribal perspective?
No, thank you, Your Honor.
Mr. Aramburu?
No objections.
Well, Ms. Reineveld, you've got the first unanimous grouping on something of substance from this group, so that may bode well for how the other ones look. Thank you.
Thank you.
I'm gonna close that email and see if I can find Ms. Volkers. Your email came in this morning, I think a couple hours ahead of Council for the Environment. But I've got to find it in this list. There it is, 10:14 a.m. on my receipt. Let me open that and do the same process here to review what you've submitted. You have some procedural issues, some environmental impact issues, and then some location-specific issues. Let me start with the procedural issues. And the first one I see is looking at SEPA question, and the second is a timing issue under 8050-100. My thought initially on those is that they're not the adjudicative issues that will pull out of the application and the specific items there. Would you be willing to file a motion regarding these items? And you know, I spoke on the record of this council pre-hearing conference 10 days ago about the position of the SEPA question. So I think, you know, my statement should be challenged in a formal motion as to whether or not we're going to take up SEPA issues during the adjudication. Do you have any concern about styling those procedural issues into a motion that you would file at some point that we agree on the timing?
Thank you, Your Honor. I don't. I do think that these should be handled through motions practice. I know that during the last pre-hearing conference, I asked for a briefing schedule to that point. Given the different discussions since then on timing, I think it makes sense to get the overall schedule worked out. But I'm in agreement with a comment that was made earlier by Mr. Rambrew that these procedural type issues could be handled through motions practice on the earlier rather than the later end of the schedule.
Yeah, I would concur because some of these look like they are jurisdictional, or I don't know that they'd be dispositive motions, but they are things that parties want to know what the ruling is right away, so that if they're ruled out of the adjudication, you can preserve those issues for appeal and maybe save yourself filing a witness on those matters that I might rule against you. So again, I don't want to prejudge any of these issues, but we are creatures of statute in this administrative law under the APA. And I'll make sure that for you, and I would imagine that Mr. Aramburu might join you, and perhaps Mr. Harper and the county, you might all consider whether a joint motion on some of these procedural issues, once we establish a schedule, is the most efficient use of pleadings, so you're not all recreating the same wheel. But I can see already from the limited discussions we've had and filings that some of these procedural issues seem to cross interests of at least three of the parties we have at the table. Ms. Volkers, anything else on those two issues?
Thank you, Your Honor. Nothing else on the specific issues. If I could, though, I would like to just confirm that we still, that this is not, our filing of these preliminary issues this morning is not a negate the joint letter that we filed with the county. And so we're still joining with the county in the identification of the issues that we identified together, including this procedural issue. This was our best faith effort to try to incorporate the feedback that you provided and our review of the orders that you directed us to. So this list is, I think, consistent with the letter that we submitted along with the county previously, and is just meant to further clarify the issues themselves.
No, thank you for that clarification. I fully agree that this is a cumulative process where all that has been submitted before is going to be in consideration as I help with other parts of the staff come up with my proposed issues list that'll be more comprehensive than the samples I sent you, but takes all of this into consideration and is a maybe by next Monday afternoon I'll have something to present in advance of that, so that everybody can say, okay, this is what Judge Torm is thinking all of the issues that have been raised so far might be that are in dispute based on the filing of the application and whatever else might have been informed by the draft EIS. Is that fair, Ms. Volkers?
Yes, Your Honor.
Okay, perfect. So let's move on to the environmental impact issues that you have. Some of these I think are pretty self-explanatory. And I'm just going through them honestly for maybe the second time today, but on the record here thinking out loud. When your issue number 5 about whether the project might negatively impact plants, wildlife, and habitat, and again you reference threatened, endangered, and sensitive species, is there is that an overlap with the tribe's gathering concern of other plants and other species that are important culturally, or is that more of a general environmental statement?
Thank you, Your Honor. I think there is some overlap, but that is more of a general environmental statement.
Okay, because I see that in your location-specific issues, you focus more on cultural properties and potential impacts. All right, well, I appreciate, I won't go through all of the other preliminary issues, but I'll ask the applicant if they have any questions or concerns about the filing that came in this morning from Ms. Volkers. Ms. Chase, any comments or other items I should consider as I review these?
Thank you, Judge Torum. So we agree that the first two procedural issues should be resolved via motion, and think that that process could occur on a earlier rather than later. So agree with everything I think that's been discussed there. As to the substantive issues labeled environmental impact issues and location specific issues, I will acknowledge that I don't think we've had the opportunity to review these in as great of detail so as to provide sort of full reactions on these, and I especially am a little, I didn't understand until this afternoon that they were cumulative of the issues that had been offered in conjunction with the county, and so want to have the opportunity to look at that overlap. So, I mean, we're happy to provide some written comments on the issues if that would be helpful to you this week in advance of the pre-hearing conference, but I'm not fully prepared to react to this issue list that was submitted this morning.
So unlike me, who's reading these for the first or second time today, you don't have some special power to divine these things faster?
Unfortunately, no, Judge Torum. My apologies for that.
All right, well, we're all in the same boat here. And I say it partly in jest because I'm working on this just-in-time schedule as well. And I want to be transparent about maybe sounding more prepared at times than I might actually be. So today, I fully confess, I was on the bench until 10 after 1 and rushed home and was on time to connect with the call, but that's about as much prep as I got today, at least for those emails that came in this morning. Let me turn to the other parties then in turn and see if they've had any further time to digest these, or maybe they've discussed them with Ms. Volkers before she filed them. Mr. Harper, did the county have any further collaboration with Ms. Volkers or comments on what she submitted today?
Ms. Volkers and I spoke after those were submitted, but what she filed on behalf of the Yakima Nation today, it's not something that we collaborated on. So it really doesn't speak for the county's position from our earlier issue statement. Okay.
Any thoughts from the county on the short amount of time you've had to review and discuss them with Ms. Volkers?
Your Honor, they generally strike me as appropriate issue statements. I'm going to join the chorus, though. I think some early motion practice would be helpful. And really, I'm just sort of interested in hearing more collective thoughts on how issues are being defined. It may be possible for the county to follow up after today with a revised set of issues of our own. I think that was something that the court was seeking, but I wasn't sure exactly how or when that would be required. And I think right now, from the county's point of view, we're just trying to get that level of sort of resolution dialed in, so it's most helpful.
Yep, I'm definitely hearing what the chorus is saying, and we have a little bit more breathing room to establish and get that done. All right, let me ask then, Ms. Breineveld, any thoughts on the tribal issues that were submitted today or comments that would guide me between now and our next pre-hearing conference?
I haven't had sufficient time to review these to be able to provide any sort of comprehensive thoughts or analysis, but from an initial reading, they look okay, but I would like some additional time to review them.
All right, and we're all going to have some additional time to flesh out the disputed issues. Mr. Aramburu, any thoughts on the list that came in this morning from Ms. Volkers?
I certainly have no objections to it. Of course, we have similar issues that we have raised. We are in agreement with the procedural issues, certainly, and we've raised issues of wildlife and other things as well. So I think it does kind of raise the question of what we're going to do with this issues list. Are we going to have a list that reflects, is there some consolidation that you have in mind, Judge Torum? Are we going to list the issues that have been brought up, sort of what happened, I guess, in Tesoro? So I don't have any objections, but I'm kind of wondering what our exercise is here as we go through this.
Mr. Rambert, it's a good question. I am trying to decide which rocks I want counsel to bring me. But frankly, what I want to do is, as you hinted, something that might have occurred in previous adjudications where the judge sits down with staff and tries to figure out where there might be overlap, tries to figure out where there might be some opportunity for simplification, and creating a way for parties that have the same issue to maybe decide who amongst them is taking a lead so that only one witness is called jointly. It may be that there's a need for somebody that, let's take this ferruginous hawk issue. Maybe there are competing experts that Tri-Cities Cares, the Yakima Nation, and Council for the Environment all see that ferruginous hawk issue slightly different, and we really need 3 witnesses. But I may come back and say, on that issue, for instance, I see that all 3 parties are raising this. It's been covered in the application that we'll find out who the applicant's witness is. And not to say that there's not a 4th party among, that might also join in that, but that's what I'm looking at doing, Mr. Ramber, is trying to go take these issues lists that have come in before the first pre-hearing conference and those in the interval between March 10th and today, and see if I can comb through this and come up with, okay, here's what I've heard so far, put them into one comprehensive list and send it back to the parties. And maybe a little ambitious to get it by next Monday afternoon, but I do have some holes in the schedule this week that might allow it. If I can get those to you by close of the week's business on Friday, then you'll have at least Monday morning to look at that comprehensive list, and we'll have a further discussion about it. And you can tell me if I'm missing anything. You can tell me which issues people might be aligned with to collaborate on a single witness as opposed to 2 or 3 witnesses on a similar topic. But again, I don't want to pretend I'm going to limit anybody. If they're a particular expert, you can't agree that you want to hire the same one, or you think that 2 or 3 experts on a topic will add to the record and help the council decide the issue. I do think what I'm trying to do is head off some motion practice from the applicant or other parties that might be moving to strike witnesses as cumulative or duplicative. By doing the work up front, it may save me and all of you some work down the road. So I hope, Mr. Ramber, those random thoughts from the judge give you a little bit more guidance of what I'm thinking.
They do. Thank you.
All right. I think we've covered everybody's response to both the Council for the Environment and the tribes issues. So, Mr. Ramber, that brings us back to the email you filed, I think, on Friday afternoon, and then filed a supplemental correction to on Saturday morning. Is that right?
Yes, a spell check caught me. So amenities are amenities. Yes.
Fair enough. I'm going to see if I can find your motion. I think I know where I filed that one. Yes. And yours was not an attachment, I think, but just a listing of Roman numeral 1 through 12. And then you highlighted that word amenities in Roman numeral 8 as the change. And I think your issues, again, speak as you've sent in previous filings. And again, I'd consider these as cumulative to the thought process. So I'll look at your initial filings from last week or last time and these as well. Did you want to say anything further about the issues before I go around the horn again to see what other comments there might be?
No, I think my issues are self-explanatory, or Tri-City Cares issues are self-explanatory.
All right, well, we'll leave Richard Ramber's personal issues off the council table for this time. Let's turn then to the applicant and see if the applicants had a chance to review the email that came in last Friday and the change on amenities on Saturday morning. Ms. Chase?
Thank you, Judge Torum. This is Ms. Chase. We've had a chance to look at this on a preliminary basis. I think, and this really goes to both the issues submitted by the Yakima Nation and any issues to be submitted by the county, as well as this one. We'd like the opportunity to provide some more detailed comments before you sort of consider these issues. But as to these, I think our overarching concern is that many of them seem a bit overbroad. and don't quite define the issue with enough specificity that the other parties can, including the applicant, can reasonably respond. And I'll just highlight a couple of those here. I think issue 7, which raises general concerns about natural aspects of our national heritage, for example, and 9, which talks about just adverse impacts generally that have not been mitigated. So I do think we have some concerns about the breadth of these issues, and those are just a couple of examples. So I'm happy to answer any questions you might have about those comments.
The only question I'd like to pose to the applicant, and if you can answer it today, fantastic. If you can't answer it today, I know I'll get something further in writing once you and your colleagues have had a little bit more time. But as we talked about with the tribe's procedural issues, number 1 and 2, that were labeled that way in Ms. Volker's filing, are there any of these 12 issues that you see are procedural in nature and would be subject to pre-adjudication motion practice to either clarify them as jurisdictional or otherwise?
I'll think on that. I don't see them as being procedural in quite the same way that I think the issues that Ms. Volker's identified in her submittal are procedural, although I do think some of them are. So just as one example, we need to place this hearing in the context of the existing land use decision that's already been issued. And so, for example, the applicant has some concerns about relitigating, and I'll let Mr. McMahon speak in more detail to this if you've got further questions today, but relitigating what's already been decided in that land use consistency order. And so when I look at issue number 3, I think that's one place where we think maybe some motions practice potentially could be useful depending on how everyone wants to frame the issues to make clear what's been decided in that order already and what remains live for the adjudication. And I'm looking to Mr. McMahon in case he has anything to add, but he's telling me he does not at this time.
All right. Frankly, I was expecting the applicant to also raise some questions of whether the scope of this adjudication could possibly take on number 1 and number 2. And I'm not saying that it can't, but as far as meaningful reductions of emissions to justify any adverse impacts caused by the wind farm as proposed and Washington policy and legislative priorities, I'm going to need some further explanation, Mr. Aramburu, for TCC's position on whether or not an FSEC adjudication is appropriate for those questions, and also whether or not the question of abundant useful power at reasonable cost is something that's before FSEC or more likely before the Utilities and Transportation Commission. And as much as these two agencies used to be co-housed, I don't think their missions are continuous. They might be adjacent in the big scheme of things with Governor Inslee and the policies he's signed into law during his terms in office, but I have some concerns and may, if no one else asks for briefing on those, I want you, Mr. Aramburu, to, as I consider these, think that I might be asking you for briefing to see if they come within the scope of 8050. So I just want to tee that up. If the applicant wasn't ready to have those thoughts today, I am. And it's just a question mark that I want to put over those. All right, let me move to the county and see, Mr. Harper, if you've looked at Tri-Cities CARES issues as submitted by Mr. Aramburu and have any comments for me today.
Ken Harper, Your Honor, I have looked at those. No particular item by item comments, Your Honor. I think one of the things that I want to comment on, though, and this is really just to really elicit a further comment from you. I think if I understand correctly, what we're doing here is we're really kind of engaged in a focusing process. And so if an issue statement is inartfully expressed, or heaven forbid, some sub issue is omitted in this process, it's Your Honor's expectation that there will be sort of a sort of funneling down to, or sifting down to, a final sort of set of issues that will then define the case. Am I channeling you correctly there, Your Honor?
Yes, your crystal ball is correct. This is
Okay,
going to be
yeah.
a sorting and a sifting. I don't have a hat like the Harry Potter school did, but we will do the sorting.
Yeah, well, Your Honor, with that in mind, I don't have anything further to add to our discussion so far, Mr. Aramburu's comments. I think his issues, I don't have anything else on that.
All right. Ms. Volkers, let me come to you next on what Tri-Cities Cares submitted. Do you have anything you want to add today as I kind of do this sifting and sorting?
Thank you, Your Honor. I don't have anything else to add specific to this list, but I do appreciate the discussion as I've been better understanding the goal here of this discussion. And so I would add that as things are sifted and sorted, and I think I preserved this ability in what I filed this morning, but we would anticipate that parties would be able to argue any disputed issue, even if they're not the ones initially listing it. So we didn't want to create duplication, and so therefore didn't list certain things that were part of Mr. Ramburu's list or Ms. Reineveld's list, but did preserve the ability to still join in the discussion of those issues throughout the adjudication. So I just want to raise that as another potential point of clarification if that causes any concern.
No, not whatsoever.
Really
I think that's the general. I think that's the general spirit, Ms. Volkers, of where we're going with this. There may be a party that decides they're the lead, and other parties are in support, but will, ask similar issues in cross-examination, but essentially adopt the previous questions, if you will, once we get to that stage. And when it comes to testimony, parties that have issues that are aligned, like let's say I list a party issue, as Mr. Aramburu's listed, the projects have unacceptable impacts on wildlife and their habitat. Well, once we get more specific on his issue number 5, which habitats and which wildlife, it may be that a number of parties have similar concerns, maybe all parties, and choose amongst themselves as to who's going to file the issue on this species and which biologist will be called on another. But all parties might have those similar concerns. So I hope that helps. That through this sifting and sorting and narrowing process, it may reduce some of the filing burden from one party, and it can be shared amongst 2 or 3. It might be that 2 or 3 parties sponsor the testimony of one witness because it speaks to all of their issues, and then I just need to know who the lead party is that will be sponsoring the witness, and go from there on further examination. So I hope that helps.
I brought this up. And
it does. Thank you, Your Honor.
All right. And Mr. Aramburu, I have your mic open right now. I can hear you in the background. I'm about to turn to Ms. Reineveld to talk about your issues there. So if you can make sure we have the microphone discipline continuing, we've been pretty good today. Ms. Reineveld, anything else on the issues filed last week by Mr. Aramburu on behalf of TCC?
I agree with the applicant that some of these issues appear to be a little broad, and so it would be great to, I guess, add a little more specificity to just understand what is being adjudicated specifically. There's also some redundancy, in all of some of these issues, both at Council for the Environment and also Yakima Nation and these issues. So I'm assuming that sifting and sorting process, as you say, that's the kind of, we're going to be narrowing these down to kind of come up with kind of one discrete question on kind of each of these issues. And then I agree with your comments regarding some falling outside the scope of this adjudication. But generally, they look fine. I'm kind of interested in what are the next steps in terms of kind of combining issues and narrowing issues here.
Yeah, and as we had at the end of the last pre-hearing conference, when you asked for next steps and on developing, well, what do you really want, Judge? I think we've covered a lot of progress in the last 10 days to get to these issue statements and to work on the neutral tone and the more specifics to the topics that we're looking at. So we'll continue to make some more steps. I want to reiterate what I said last time about these proposed issues having a basis in existing law. And if there is a good faith argument for some of what I'm indicating might not be within the expected scope of the adjudication, when the motions come in to say, Judge, here's why we think you're wrong, or at least based on comments you've made at pre-hearing conferences, here's why we think this is a legitimate issue under 8050 and other applicable laws. That's the kind of motion practice I expect to see if the issues are essentially flagged for a need for pre-hearing motions before they're added to the list. From here, Ms. Reineveld, and to all the other parties, what I hope to do is take everything we've talked about today, the filings that came in by email last Friday and this morning, and all the previous letters that came in based on the parties' collaboration before the first pre-hearing conference, sift and sort, come up with that comprehensive list and get it back to you. I'm going to see if I can work independently and then with SX staff, including Mr. Thompson, to refine that so it's not just my thoughts, but that I have the benefit of the AG's office opinion as servicing the council and any other staff members that might want to help me to comment on that. Some of those may be more substantive and citing staff. We might have some of the SEPA staff involved, and definitely just the good minds of the rest of the ladies and gentlemen that are supporting this adjudication in the background. They've had some great insights along the way, and I want to continue to take advantage of what they're hearing from their perspectives. So I think that's what really all we can get through on issue number 5 on my agenda today. And I once again, I have some homework to turn around for you. I think on discovery, on item number 6, we've covered as much as we needed to before the break. So let's turn to the last item on today's agenda, pre-hearing motion practice and briefing. Clearly, until we have a better look at the schedule, and I look at all of the other things about when testimony might be due and have a proposal for you on that next time around, the deadlines for non-dispositive motions will probably be set in the timing after pre-filed testimony comes in. So I don't know how long we'll have in between, so maybe my questions on this are premature, but I think it's good practice to have all the motions decided with time for parties to file a motion for reconsideration before the first day of adjudication. So that's the thought process I'm looking at, and again, a good reason why we maybe settle on the adjudication dates and then roll backwards as far as we need to get this motion practice in between testimony filing and then back to what's realistic for that first round of pre-filed testimony. Ms. Chase, any thoughts on that?
Judge Torm, this is Ms. Chase. I'm thinking, and I don't think that I don't have any particular thoughts on that other than I agree with that general comment about the importance of having the issues resolved, prior to the actual adjudication. But I think we're flexible on how you would like to set those deadlines. And if I think of anything else, I'll let you know, but that's my initial thought on that point.
There are a couple of issues before I let you go back, that I think some of the ones that the tribe has flagged as those procedural issues that I don't think we really need to wait for the filing of testimony. This may be a simultaneous or even before the testimony comes in motion practice, and we can talk about a schedule for that next week. But I hope that all the parties will kind of collaborate and say, these are some issues that we are prepared to file a motion sooner rather than later that are not dependent on the filing of testimony as proposed for pre-filed or responsive or rebuttal testimony. But some of these scope of adjudication issues, I think, could be handled well in advance or simultaneously with the parties filing their actual testimony. So that's what I'm thinking about, kind of 2 different timelines or time periods for motions to come in and be decided. Does the applicant have any thoughts, again, on 2 periods of time, or should we put it all off until after testimony is filed?
Thank you, Judge Storm. This is Ms. Chase. That clarification was helpful to me in terms of what you were thinking and asking. And yes, it's applicant's preference that we do set an initial motions deadline. I think it would be a motions deadline that would include, among other things, as you noted, motions on the procedural issues that the Yakima Nation and others have indicated they may wish to raise. as well as to the extent that it's not resolved as part of the issue shaping and sorting process, motions on some of the issues such as TCC Cares issues 1 and 2, or issues that may be redundant as the existing land use approval process that's already taken place. So I agree with that. I agree that we can do that sooner rather than later. I think we could set that deadline pretty soon after the pre-hearing conference on the 27th, and that could run in parallel with the parties' preparation of the pre-filed testimony. In other words, we could get those motions resolved hopefully either before or while pre-filed testimony was still being submitted, so that we can keep the process moving.
All right, thank you. That's kind of what I'm thinking as well, but I'm open to other parties telling me we should wait even longer on some of those, because if they are dependent on the testimony, or at least a finalization of the issues list, which again, that would hopefully be sooner rather than later. Let me turn to Mr. Harper for Benton County, get your thoughts on those same questions.
Your Honor, Ken Harper for the county. My concern is that I generally think that it would be helpful to get some motions filed sooner rather than later. I think that almost seems like just should certainly be allowed. But my reservation, Your Honor, is that it's not necessarily clear to me how we will decide what is a procedural issue that might be subject to some kind of early cutoff or deadline compared to what may not be a procedural issue. It may be that a procedural issue seems substantive, or vice versa, only at some later date. So I think my suggestion would be if you could indicate to the parties that motion practice is open and encourage early motions on procedural issues that may help streamline matters. I think that might prove to be more manageable. I'm just not totally convinced that it's going to be helpful to have a hard cutoff on something that is, sort of perceived to be procedural at this early stage of the adjudication. Other than that, Your Honor, I do support the idea of getting motions filed, and I think most of the parties that think they have a motion would probably like to file those soon. So it may be that it's sort of a self-correcting thing to allow motions and then not necessarily worry too much about deadlines over procedural versus substantive categorizations.
All right, well, I think that's fair. On some issues, I think the Supreme Court has said you know it when you see it. And others, as you say, develop over the course of litigation. I like the idea of having kind of an open filing for that the judge says, yes, this is the time to file your initial motions, and that we'll have another round after testimony. Again, I don't think I can preclude and just, tell you don't file a motion if you think you have one at any given time now that the adjudication has been commenced. I'd appreciate parties following some guidelines if we can agree on windows of time. But I also will say if you file something that I think should be for later, I may issue a preliminary ruling just deferring any further action on it until another date certain or milestone in the process. So I like what Mr. Harper is suggesting. And if I see something that I think is just not ripe for action, I imagine either with responsive pleading or on my own sua sponte, if I read it fast enough, getting an order out telling parties, hold off, don't put your energy into this until later, and we'll tell you what the response deadline is. That's the kind of thing I'm thinking, Mr. Harper, based on your comments, might be helpful for all the parties. Is that fair enough?
Yes, Ken Harper again for the county. I think that what you've just said, if I understand it correctly, is maybe a transition from the sort of distinguishing procedural from substantive, and instead thinking of initial motions as the parties may perceive them, and then Your Honor sort of picking up the the motion as filed and then responding to it. If it's an initial motion that's procedural, then great. If it's an initial motion that's substantive and premature, then you can make a ruling accordingly. And if somebody holds back on what is perceived to be an initial motion and they hold it back, then I suppose it may not be very well received. But I think that's the kind of idea, initial motion opportunities that the county would like to see, and frankly, that we would like to take advantage of.
All right, well, thank you. That's helping to guide the discussion quite well. Let me turn to Mr. Aramburu and Tri-Cities Cares and see, Mr. Aramburu, you've been in these motion battles before. What are your thoughts?
Well, I kind of have a general thought about how we proceed here. I've looked at dozens of pre-hearing orders, and many of them are pretty specific as to deadlines, events, those kinds of things. Judge Torm, are we in a position now that perhaps you can put together what would be a pre-hearing order for draft consideration by everyone, and include within that the sets of deadlines that we know we're going to have to deal with? Testimony is certainly one. There may be objections, motions to strike. That would be another one. There would be opportunities for discovery, motion practice that would be included. And I think it would be good for, at least in my opinion, for us to take a look at this comprehensive list of things and start to, and leaving dates blank, again, is my suggestion, so that we can start to fill in these issues. Now, more specifically to the motions, obviously there may be procedural motions that are being discussed. A dispositive motion would be one that would seek to get rid of an issue, if that's something that the parties have in mind. And then there may be motion practice following the submission of testimony. And again, the pre-hearing order would set times and dates and responses and reconsiderations and all those kinds of things. So I hope I haven't gone on too long, but I think we're probably at the point where we really need to start to look at that really comprehensive order. And deadlines for motions is certainly one of those things that we would need to fill in. But I kind of think that I think Ms. Volkers and Mr. Harper pointed out, we kind of need to work backwards on these issues to kind of see where we are instead of trying to do it forward. So that's my suggestion.
And I appreciate that, Mr. Aramburu. I like the idea of, and I will have a skeleton order laying out all of these things, and I'll be filling in the dates that I know I can, or a date range, and maybe the sets of intervals. Once I have a chance when we hang up today to review the applicant's extension request and see what Mr. Thompson and I can work with to getting a more expedited review and decision on that from the council, then we'll have a better time frame on picking a date to work backward from. So you're right. I've got some homework to do as I look at all those non-availability and what the rest of the calendar holds through September 30th to start giving you those, here's the hard and fast dates or date ranges, and then figure this whole thing out as you suggest. And that would include, it sounds like, a preliminary round of motions followed by a post filing of testimony round of motions, exactly as you suggest, for motions to strike, or maybe a dispositive motion to strike an issue altogether. I do hope that in that time frame that I'm referring to now, the parties will also see where there might be agreement, and if there are mitigation measures that could be agreed upon for a particular issue, settlements of certain issues that might obviate the need for testimony or disputed cross-examination of a witness, or maybe just limit it for things that the council might still have questions on where the parties have a meeting of all 5 minds, the council may still have its own concerns that they want to ask. So those are some other thoughts I'll add to your skeleton order and overall comprehensive timeframe and chronology. I hope that's responsive, Mr. Aramburu.
I think so. And there is a question about one of the issues that perhaps we could seek some guidance on. There is an issue that's been discussed about the need to have the final impact statement available for the adjudication. But that, given some extension in time here, it may be that if the final impact statement is going to be out in advance of us getting into the adjudication, that's not really an issue. And I wonder if we might get some guidance from staff as to dates that we might expect to see that document.
All right, I'll let Mr. Thompson and I will talk to the appropriate staff, see if they have any news that can be shared with everybody, but again, without putting any undue pressure on them to finish early. And as I said, maybe there's still need for the legal briefing on that, so I can make a formal ruling on the suggestions and comments I made last pre-hearing conference, Mr. Aramburu. I don't want to make you do work just for if you think that the FEIS would somehow be done sooner and obviate the need for the motion. But if I can give you a date certain, if it's available to me, I'm happy to pass it along. All right, let me turn to Ms. Volkers and the tribe and see on this discussion of the overall schedule and the motions timeframe as we wrap up today's conference. I'll come to Ms. Reineveld last. Ms. Volkers, any thoughts from the tribe on this matter?
Thank you, Your Honor. I think I'm most aligned with Counsel for Benton County here, although I do support the request for kind of sketching this out. And I certainly would just reiterate, and I think I've already said this, that we think a hearing should be set and we should walk back from that. So I think that the proposal that Mr. Harper made makes a lot of sense. And rather than having a cutoff for motions, necessarily next week, as I think I heard from Ms. Chase, but to have a period of time where those preliminary procedural issues can be dealt with, certainly also around finalization of the issue statements, I think is a really good idea. The only other thing I would add to that is that in understanding what you just said about the work that staff is doing on the FEIS or supplemental EIS, I'm not sure, but it did sound like the discussion last week was about a proposed schedule. And so if there was any finalization of a schedule during the next FSEC meeting, that would be helpful to inform the deadlines that we're talking about. And I don't know if that would moot or not moot a procedural issue without knowing more about the schedule, but that would hopefully help inform a deadline for procedural motions.
Okay, I think I understood all of that. Let me turn to Ms. Reineveld and see if she has anything else on the motion practice as it fits into the overall time frame and thoughts on any issues that might be teed up earlier rather than later.
I don't have much to add. I agree with what the parties have stated, including Ms. Volkers and the other parties, as I stated before, that we should set a hearing and then walk back from there. And I agree, Judge, that the procedural issue motion deadline should be when we're set. And we can absolutely start having that motion practice as kind of the first part of this adjudication.
All right. Those are all the things that I had for today. The comments that I've got on item number 7, that's talk about pre-hearing opening statements and any supporting briefing, and of course, post-hearing closing arguments and briefing. I just want the parties to anticipate there'll be an opportunity to file those in writing. There's going to be just a lot of reading for this council. And I don't know that any of our council members have participated in an adjudication before or in any complex litigation where they've got to be decision makers and digest all the information. So as you think about between now and next week, the witnesses you're going to be calling in the months ahead and the position you want to put in front of the council members, any opening statements or opening briefing that you present, consider the audience. I'm not hinting at all that they're unrefined in any way, but just their inexperience at these matters, and a concise opening statement that you want the members to read essentially on the morning of the first adjudication date. I'm thinking they could read 3 to 5 pages and capture what each of the 5 parties is going to say as an overall perspective. And then they'll be ready witness by witness, topic by topic, however we schedule the dates of up to maybe, as you said, 2 weeks of adjudication. So I just want you to think about, as you structure things, what that opening statement filed in writing might be, so that at my insistence, they'll have read that before they hear the first witness and be teed up to hear what each party is going to have based on whatever order we present it. Now, when the adjudication's all done, that in my experience is when you really want to have a chance to file that post-hearing brief so that I can digest, with Mr. Thompson's help, all of the legal issues you might be raising and answer questions from the council accordingly during their deliberations, and that they can hear, based on what the testimony showed or perhaps didn't through cross-examination, have a better view of, here's what we've heard, and here's what the parties really think this is why we should do X or Y with particular impacts for mitigation, or perhaps with the overall project and its recommendation for approval or denial to the governor. So the opening statements, I just think you don't want to be too much time on your positions, but more again about what you want them to pay attention to over the course of the adjudication. Save that super advocacy role for the post-hearing brief. Then the council will be in a better position to understand how and why you're taking the positions you do. I hope that's helpful. Just in this sort of practice, it's not a criminal proceeding. It is a explanatory proceeding, an evaluative proceeding. It's truly an adjudication of all the issues that we're going to settle on. And I hope that sets a tone for when I put that in there for pre-hearing opening statements, what that means, and post-hearing closing arguments. I know those are words that we all learned in law school, but sometimes statements and arguments get confused. And I just invite you to, as you develop your cases, keep that in mind. I don't think anybody's going to move to strike an opening argument as too, an opening statement as too argumentative in this position. But if we all keep that in mind, no one will even think to. Let me go around the horn and see if there's any other issues that were left unaddressed. Ms. Chase, anything for the applicant that you wanted to bring up before we close out today's conference?
Thank you, Judge Torn. This is Ms. Chase. Nothing further for the applicant. Thank you.
Mr. Harper, how about for the county?
Ken Harper for the county. Nothing further. Thank you, Your Honor.
Ms. Reineveld, Counsel for the Environment?
Sarah Reineveld, Counsel for the Environment. Nothing further. Thank you, Judge.
Ms. Volkers, anything on behalf of the Yakima Nation?
Thank you, Your Honor. Shawna Volkers, on behalf of the nation, we have nothing else at this time.
All right, and for Tri-Cities Cares, Mr. Aramburu?
Nothing further at this time, Your Honor.
All right, well, our conference then is adjourned at 3:47 p.m.